Welcome to the COVID-19 webinar, Out of Quarantine and Into the Fire. My name is Cynthia McFarlane. I am an equine law mediator and barrister. Today I'm going to address 3 points that I believe may help you in your equine-related businesses. The first, I'm going to be dealing with prevention, what you can do during lockdown to prevent you from going through legal disputes in your businesses. Secondly, what you can do if you're going through legal disputes. And thirdly, essential tips that I believe help equine business clients that I have if you are going through such disputes. But first, I'm going to ask you to think about the reactions that you may have had during this difficult time of the pandemic. Was your reactions one of burying your head as a business in the sand? Were you waiting it out and relaxing through this process? Are you stressed? Are your staff stressed? And fourthly, are you planners in your businesses? So what have been your reactions during this time? Well, the economists have described the process as being compared to the Great Depression. But what are the aftermath effects of COVID-19? What are the unforeseen events or consequences? Well, with the coronavirus, there has been, to some extent, foreseen, to some extent unforeseen, loss of work, loss of business, and homelessness is also an unforeseen consequence, perhaps, of the pandemic. Now, David Cameron said in the UK about 10 years ago that we're all in this together. And the approach taken by the UK government has been to allow social distancing, furloughing of staff, deferring tax and VAT to 2021, and providing businesses, if they qualify, for business loans. More specifically, the approach has been to introduce the coronavirus job retention scheme, the coronavirus business interruption loan scheme, the coronavirus bounce back loan scheme. They depend on certain thresholds that your businesses reach, and it's up to you to obviously consider those. But also, if you're smaller businesses, some councils have provided small business grant funds. There is a self-employment income support scheme and the Universal Credit Benefit State Benefit Scheme. So a number of ways in which the government in the UK has approached matters of this unprecedented time. The difficulties are clear, and equally it does appear that we are pulling together at this time. In other countries, there has been a number of airlines that have been affected, and in the UK, Flybe UK. There have been shops, restaurants in the UK which have suffered and either gone into administration or lost staff, had to close down premises permanently, and they include Debenhams, warehouse and restaurants such as Carluccio's. And there clearly are other areas which have been affected and which retailers are temporarily closed. So we're all in this together until we're not. And that takes me to what I have witnessed and observed and certainly seen in terms of clients and the scale of inquiries that have come in since the lockdown, and in fact leading up to the permanent lockdown period. So we have livery fees, we have disputes between the yard owners with regards to those, disputes between owners of horses, donkeys, and having access to those during this time. We have concerns about the welfare of the equines, whether they were receiving suitable diet, nutritional feed, whether there should be a lifting of restrictions across the board, and whether those restrictions, as I say, should take place, or whether the business should continue as usual with social distancing in place. As far as equine business disputes are concerned, they vary, they're wide and varied. Pattern, branding, product are perhaps matters which affect all the different services providers that are here in this conference. Technological advancements are also disputes which may arise between competitors, contractual agreements, and to a certain extent there are cases that I see, disputes that I see involving veterinary negligence. Equine business disputes will continue and perhaps increase, is how I would predict it, in terms of loss of staff, employment contract disputes, and whether there was availability of PPE within that particular business for those staff members, or whether those staff members were required to carry out services to the public or internally with other staff without that equipment in place. To what extent the business was able to continue and thrive. I'd also predict loss of equine businesses in the sense of insolvency, administration again, and to a certain extent voluntary agreements or involuntary agreements, and whether winding up orders will take place through the courts. Now, again, a big question which I foresee would arise subsequent to the pandemic and when businesses are fully up and running, whether breaches of contract have taken place as a result of COVID-19 or not, whether businesses are able to continue with the debt, whether they need to recover that debt, whether they can enforce that debt, and also whether during the course of the pandemic the business has in fact damaged, or whether there's been some damage to personal reputation with those running the businesses. So those are all the types of disputes I've either seen already during this period, what I've dealt with prior to this period, which I imagine will increase, or what I foresee will have an upward trend after all business starts carrying on as normal. Now, the government guidance is something which many businesses here may not have appreciated, but in the UK there has been on the 7th of May a publication where the Cabinet Office has provided guidance, written guidance. It's responsible contractual behaviour and enforcement of contracts. Now, it's geared towards individuals and businesses during the COVID-19 period. And I've put in bold here, highlighted areas within the 5-page document where I think will assist the businesses who are here during this conference. So it's looking at parties who have active contractual arrangements, paragraph 4, which are materially impacted by COVID-19, and that they should consider their behaviour as part of the national response to the public health emergency that we are currently facing. It says at paragraph 5 that the contracts or involving the contracts, that we should be responsible and fair in our behaviour as far as those contracts are concerned. And this will result in a better long-term outcome for jobs and our economy. Bad behaviour will be bad for jobs and will impair our economic recovery. Over the page, again, strongly encouraging the businesses to be responsible and fair in their performance and enforcement of such contracts. And at paragraph 14, that the businesses are acting in a spirit of cooperation and aiming to achieve practical, just and equitable contractual outcomes, having regard to the impact on the other party or parties, and aiming to achieve practical, just and equitable contractual outcomes, having regard to the impact on the other party or parties, the availability of financial resources, the protection of public health and the national interest. And lastly, at paragraph 17, the government would strongly encourage parties to seek to resolve any emerging contractual issues responsibly through negotiation, mediation, or other alternative or fast-track dispute resolution before these escalate into formal intractable disputes. So that's the government's approach to what they consider is relevant during the time of the pandemic. And that leads me nicely on to the next stage of this webinar. And again, I asked the question, what was your reaction been as a business? Is it one of these things, or was it all of these during the pandemic at various times? As has been said already, I am an equine law mediator and barrister, and I've been doing this for 14 years as a barrister and 5 years qualified as a mediator. I also undertake continuing professional development courses as expected of professionals, specifically in relation to horses and their disputes, or disputes surrounding them. My background is set out in italics, but what I want to deal with more specifically is that I have created for specifically my clients a 3-stage legal process, and it's to problem solve really your legal problems. And here is the 3-stage legal process. Prevention, that's preventing you getting into legal problems in the first place if we can help it. Damage control, that is mediation, which I will get onto what that means more clearly in a moment. And damage limitation, if you are in the course of litigation, the court process or tribunal process. So prevention, how can I avoid disputes in the first place? Well, usually I would say to my clients, budget for legal issues, and this is perhaps the worst time to be saying that. However, it might be that you are lucky enough to be in a position as a business to have money available, and in that case I would ask you to look at your budget, because it's normally when things are unforeseen that unfortunately legal disputes arise, and then it's grappling at that point to deal with the issue. But I would ask you again to then consider your insurance policies, which may deal with the legal expenses, and decide whether that needs to be considered again. During this period of the pandemic, whilst we're still in quarantine or lockdown, stage 1, I would ask you to consider maintaining your staff morale or promoting staff morale in a number of different ways, which I'm sure you're aware of within your business. But keeping in touch with staff, if permissible. I say if permissible because I appreciate that if you have furloughed staff, you may not just be able to speak to them about work, but you can obviously keep in contact with staff in a different way, socially. So those are ways you can prevent perhaps some disputes arising in respect of your staff or employment. issues. We have reviewing clauses in staff contracts. Now that is important. Relook at those. Relook at the staff contracts as far as alternative dispute resolution clauses are concerned. So something where an issue may arise, can we look at either mediating it or considering aspects that go away from litigation and the court process. Really important, I would say, to also try to have a culture of mediation in your businesses, if you haven't already. I appreciate you have varying sizes in this conference, but if you have a culture of mediation, of discussion, of amicable arrangements, it's really important. It would mean that you are not heading in the direction of litigation if you can help it. And it's doing those things early on would make life easier. So we're not trying to firefight in terms of those disputes down the line. Undertake risk assessments. Now, I don't necessarily mean that purely for COVID-19. Look at your risk assessments, look at your health and safety policies, any staff policies that you need to be looking at. These are the times that you might be available to do that, because when we get busier again, it's unlikely that this will be the first thing you'll have in your mind to consider as a business. Any care plans that are important to the horses or other equines that you have. All of those points, not just for COVID-19, as I say, but forward-looking as far as your business is concerned long-term. Now, what do I do as a mediator? Well, mediation is where we have, I've got here, a mediator is chosen by the parties. So both parties decide on a mediator, and the mediator's role is to facilitate the parties' disputes, not to decide it, but to assist them in them deciding their disputes, agreeing the issues and resolving the issues. Usually the parties meet in a joint session with the mediator or in caucuses. That's in individual rooms, each party in a separate room, and discuss with the mediator the issue. Ideally, the person with authority to settle will be present or at least accessible by the telephone. It's very hard, and I'd say we are unable to agree anything if no one has authority to make decisions. So that's a very important part, that someone with authority is either in the room or available online or by telephone. And what the mediator then does is shuttle between the two rooms, or more than two if there's a number of parties involved, and trying to facilitate, assisting them with the dispute. Now, alternatively, mediations are not face-to-face, but remote. And this is something that has happened prior to COVID. It's been happening for quite a few years, in fact, quite a long time. But clearly, in this current situation, it's extremely important that mediations do go ahead and they can be dealt with, addressed, conducted online, either through Zoom. I think that's the preferred option, really. And the agreement can be set out again online quite easily with the parties. And the mediations itself can be dealt with nationally or internationally. And that's always been the case as far as I've been a mediator. So this pandemic is not causing problems at all. If anything, it's making life a lot easier, and it reduced costs, which is something I'll go on to in a moment as well, because travel fees are not in the picture. Parties are accessible, and in fact, to some extent, the parties are more free via Zoom to have private sessions or group sessions, whereas face-to-face it can be rather difficult for parties to feel that they can discuss with the other party. So do I need a mediator? Well, mediation is a fast process. It avoids the cost and time of litigation. All parties can leave happily, and it can even repair your business working relationships. It can be used at any stage, pre-action, during litigation, or during court. So it's during the court process. There can be adjournments in order for the mediation to take place. There can be postponements of hearings in order for the mediation to take place. So even at that later stage, you could be reducing costs rather than risking them with a decision made by somebody else, a judge, that you have no control over. Choose a mediator based on their CV is my advice to you. Expertise, lawyer or non-lawyer. There may be a professional expert that also is a mediator, for example, an engineer. And it might mean that that person is a preferred option for the type of case that you have, which is an example. If you want to use somebody you or the other side has used before, that's very important to consider that, because you might feel, and it's just a feeling that you might get as a business, in your business, that you don't want the other side to use somebody that they know, because you think they may have a personal relationship with them and they may find against you. It's unusual that that would happen, but certainly that can be the feeling that one party takes. Extraordinarily, however, most parties find that they will go with what the other side has wanted. I don't really understand the reasoning behind that, but that does happen quite a lot. That if someone has been used before, in my experience, they tend to, the other side tends to go with that particular person. Again, it's your choice. You make the decision. And you may want to be deciding whether you want to be represented. Now, again, that might depend on the type of business you have, and more importantly, the financial budget that you have as a business. But ordinarily, as a business rather than an individual, you may want to be represented. And there are advantages and disadvantages in that, which we'll come on to in a moment. But my essential tips in terms of mediation is this. Make sure your bundle of papers, your file or files, they'll normally be large files for businesses, make sure that they're prepared in advance. Make sure the opening statements, because each party tends to provide an opening statement in writing for the mediator, make sure they're sent in good time. It does get the mediator on your side when you have prepared those matters in time. Make sure that the mediator knows exactly your position and your side on the case. You may want to take advantage of a pre-mediation party discussion with the mediator. That is normally a telephone call or a Zoom meeting with the mediator, which is without the other party, and that is giving you an outline to give to the mediator and to a certain extent build the rapport, the summary of the outline of your position. And I would say invariably that does take place in the UK, either by telephone or Zoom or some other form. And it's really important, if you want to discuss matters which are confidential, that you don't want the other side to know about. You might have a summary of the case, which is in the bundle, an opening statement or an outline that both parties see and the mediator clearly sees. There may be some additional information that you don't want the other side to see, you'd like the mediator to look at. That confidential disclosure can be given in writing, or it can also be discussed perhaps the pre-mediation party discussion. So that mediator's eyes only or confidential disclosure paper is there as an option for you. I mentioned earlier that representation at the mediation may be advantageous or disadvantageous. what I would say to that is that some counsel or barristers or solicitors may use this incorrectly, this process, as another way of a pre-trial litigation, and that becomes quite argumentative, and that can push parties away, pull them away from the mediation process and the potential of settlement or agreement. So that's why I'd say, to some extent, it can be difficult and not a good reason to have a solicitor or counsel present. And equally, that applies to a third party. Now, a third party may hinder or assist. Perhaps they hinder more than assist. Arguments may go that way. A third party is there for support, but again, you need to choose wisely who your third party person is, whether that's a member of the business, whether that's somebody outside of it, who that individual is, whether they are going to assist you in settling, agreeing disputes. Heads of agreement tend to be areas of agreement. Doesn't mean that you've come to a decision, an agreement. A settlement agreement is where you have come to an agreement that can be considered subsequently as final in the mediation. The psychology of mediation is interesting because there are a number of factors that are not immediately clear to the parties, and that is this. For example, you may have a small business against a large business, and it might mean that the location of the bigger business might be something which the small business feels is uncomfortable for them to be at. And so they may want to look at a neutral venue where both parties feel equally intimidated or equally comfortable. It might mean that you have a bigger room and you're a small business. It might mean that the bigger business has the bigger room. And it's quite a lot of psychology that goes on in mediation, which I can't deal with in this webinar here. But these are factors to bear in mind. For example, if you're a big business who wants to agree with a smaller business, you may not want to take the bigger room. You may want to give the bigger room to the smaller business. And I think you perhaps get that reasoning behind that example. Equally, refreshments, small points it might appear on the face of it, but in terms of getting someone to agree something, these are factors that may need to be borne in mind. Listening to the parties. This is not about arguing sides, contesting matters as if you were in court. This is about hearing the other side. A lot of mediation involves not just the financial terms, the end result in terms of the monetary terms, but also emotions are involved, values are extremely important, and beliefs, and they all are really relevant in that, and it's something that you won't get in a court hearing. And that is why perhaps when you get to court and perhaps lose or win, but not winning on the things you really want to win on, this becomes an important option or a relevant consideration for a party. So the new normal, what is the new normal? We've been using this term a lot in England, and I guess no one will know what the new normal is. What is clear from looking at not only the government paper, but living life during the COVID-19 period, is that a lot of people are extremely sympathetic, more sensitive, more considerate, and looking at things in a slightly different way, being more mindful. And so there's a hope of many that after the pandemic ends, after things die down and we enter back at work permanently, that we would have learned something during this period. And so the hope, as far as mediators are concerned, particularly myself, is that it may mean that conciliation, consideration and sensitivity are terms that we've learned to move forward. And it might mean that mediation, I predict that it will mean that mediation becomes a bigger area in the legal world. Significant now, particularly for businesses, but other smaller businesses or individuals may well consider it as an option rather than being forced into litigation and entering the court process. However, if you do enter the court process, what you need to bear in mind, given that you are equine-related businesses, is to consider a solicitor, which I'm not, or a barrister, which I am, experienced in equine law, a direct access equine law barrister. That means that you can deal with clients directly, which is what I do, businesses and individuals, but also am instructed through solicitors, and that is also something that takes place in my field. And I often get instructed by solicitors, particularly on more complicated cases. It's important in terms of businesses that we are looking at preserving your reputation. The lawyer that you use needs to be aware of the protocols for the particular countries that we are concerned with. Experience in bringing claims as claimant and defending claims as defendant, and dealing with cases which are small, medium, large cases as far as the financial area is concerned. But given that we are not only talking about the COVID-19, but we are talking about being clear on limiting costs, it's important that someone is experienced enough to manage the risk in the right way, considering settlement proposals, which is what mediators do, as well as barristers, as well as solicitors, and looking at how to enforce debts, which will be something for a major feature, I would predict, going forward. And to a lesser extent, perhaps in the context of the people that are attending this conference, disciplinary hearings. Disciplinary hearings would be whether there's any regulatory issues which might apply in terms of products, might apply in terms of regulations which are not complied with, and any government guidelines, etc. But yes, those are the areas that perhaps ought to be borne in mind when considering legal representation if you get beyond the amicable stage and to the point of litigation involving court or tribunal. Now, given that we are in the COVID-19 period, I have decided that I would like to use this time to assist businesses, whatever your size, whatever your country, given that this is an international conference, to assist you as far as I am able as in relation to business strategy, legal business strategy. And so what I'm laying out to you as attendees of this conference is a free legal business strategy call or Zoom meeting, if that assists people, where you can set out your individual concerns at whichever stage of the three-stage legal process. If you need to prevent any legal disputes, I can deal with that, assist you with that. If you are looking to know a bit more about mediation and how that may assist you in your businesses with your legal disputes you may have, or if you are at the litigation stage but are looking at potentially working out next steps, working out whether you need representation, or working out anything else in respect to that point, I am able to assist you during this COVID period and shortly after that, because we do not know how long this pandemic is going to last for, or the consequences, I should say, of the pandemic at this time. And to assist you as far as the contact details are concerned, I have set out my website, thehorsemediator.co.uk, the horselawyer.co.uk, they go to the same site, and my email address is here, work mobile number, my chambers office number is there, and Twitter is also available that way. I hope you enjoy the conference. I hope this gave you something to consider during this difficult time, and I wish you the best of luck with all your businesses. Thank you.